Welcome to the latest episode of Gowling WLG's Listener Podcast, where we look at a range of topics trending in the legal and commercial landscapes.
Hello everybody and welcome to our Contract Law podcast, where we look at developments in contract law and court cases to draw the lessons from them about contract law. And we do this from the perspective of somebody who drafts and negotiates contracts, but also from the perspective of somebody who deals with disputes and litigation to try and give that rounded perspective. I'm David Lowe. I lead our commercial contracts team and I draft and negotiate contracts.
And I'm Andrew Smith. I'm a commercial litigation partner and I obviously look at disputes, but how to try and de-risk problems for clients.
So Andrew, what have you got for us today?
Well, today, David, I have Barton, which is a Supreme Court decision. So it is a judgment of the highest court in the land, so it has quite a lot of authority. And unusually, it's about relatively straightforward facts. So let's go into those. Let's say you own a valuable property and I tried to buy it, but it falls through. And then I think, I can probably find a purchaser for this. So you and I enter into a contract, and that deal is that in the event that I introduce a purchaser to you, and that purchaser buys your property for £6.5 million, then you will pay me £1.2 million. That is the contract. And so what the Supreme Court had to decide was what happens in this situation. So the property is sold to the person that I introduced to you, but you were only able to sell it for £6 million because something was found in relation to the property which reduced its value. So do I get any money as a result of it being sold for £6 million when the deal we did was that I'd get £1.2 million if it was sold for 6.5? What do you think the answer to the question is?
Well, the contract is, if you bring me a £6.5 million purchaser, I'll pay you £1.2 million. Well, if you fail to do that and bring me a lower value purchaser, I should pay you nothing. Is how I see it, because I would have said something in the contract if I wanted to have something below that threshold.
Well, and I don't often say this, David, you are right. The majority of the Supreme Court, but by the slimmest of margins, essentially found the way you have just stated. The minority and the entirety of the Court of Appeal, whom they overruled, found differently and found that he should be entitled to a proportion, effectively, of the £1.2 million fee.
And I think an immediate reaction is, I'm pleased, of course, the Supreme Court might agree, but it's interesting that it's only by the slimmest majority that actually, as you say, what is a relatively simple set of facts, that there can be so much debate amongst the most senior judges in the land. And it only just went in the property owner's favour. You know, it could so easily on another day gone the opposite way. And therefore, on one level, as a contracts lawyer, I'm pleased to hear the court ultimately determining the contract says what the contract says and is sticking to it. But on the other hand, I'm worried that on another day, they might have said something slightly different and they would have added to the contract, which I, as a contracts drafter, wouldn't welcome. I, as a contracts drafter, want the contract to say what the contract says, full stop. I don't want somebody coming afterwards with the benefit of hindsight and going, yeah, if they thought about this, they would have said this. That's not helpful.
Yes, I think the reason why there was so much disagreement within very senior judges was not because of a disagreement on the facts. It was on really a disagreement on principles. And really, to summarise those principles, it's really about a sort of mind the gap issue, which is if a contract states something, but it doesn't cover every eventuality, was it the parties' unexpressed intention, which is how an implied term would be put into a contract? So obviously an implied term is put into a contract by the court when it hasn't been expressed. And so do you fill the gap with an implied term, or has effectively the gap, the silence, been deliberate because the contract expresses what is going to happen, and if it isn't covered, it's not part of the contract? And I think this sort of almost in principle issue is part of the continuing trend, which is away from a purposive interpretation in the contract, where the courts have the maximum opportunity to find a just result, and a slightly more old-fashioned and now more in vogue view, which is that the contract does what it says on the tin. It is not for the courts to fill in the gaps. It is not for the courts to decide what the contract should have said in order to be reasonable. The court is there merely to enforce what the parties have agreed. And I think that's why this case is not complex in fact, but complex in law, and is a part of something relatively deep, almost on a philosophical level.
Yeah, and I agree. And it's, of course, I think for the purpose of a contract drafter and also businesses generally, overall, it's in the interests of all business if you have certainty that what the contract says is what it says, because then we all can read a contract and know what it says. While if you get to a situation where courts feel a need to fill in the gaps, as you said, with all kinds of stuff, then that introduces uncertainty into your written contracts. So it's in the overall interest of business for courts to be sort of pretty narrow and stick to the letters on the page.
Yeah, so indeed, if in the individual case, it might be that it provides injustice in that individual case, but it is in the interest of justice because everybody knows where they stand, which will actually mean fewer cases going through the courts because there's less wiggle room, less room to manoeuvre, and less use of me and more use of you, David, which I'm sure you're very happy with.
Hurrah! We're always very happy about that. I'm not saying, by the way, that there's never a place for implied terms. And actually, anyone is trying to argue that their contract has got some implied terms. This case is an excellent summary of all the different angles of how you might be able to imply terms in it. It brings it all together, doesn't it? There's the estate agent's case Dividing from 2019, which is, again, a estate agency contract where the estate agent said you take 2% commission, but he didn't say when or how, what the scope of that was. And the courts were relatively quick to imply that that meant 2% would be paid on completion from the completion monies. And I agree with that. They were filling what was unsaid and what the part, as you put it, the unexpressed intentions of the party. And it was essential. You know, if you got like 2% commission, you've got to go on to work out, well, when is it paid? So in that case, I agree that the courts are right to imply some terms. In the same way, I think the dissenting judges who thought they needed to imply that Mr. Barton got paid a commission if he got less than 6%, I don't think was necessary. They were just feeling sorry for him. And I don't think that has any place in contract law.
No, and that's an understandable perspective. I do think that the facts of this case, whilst, as I've said, they're quite simple, are quite unusual. Although a party has introduced somebody who buys a property, one of the things dealt with in the case was that the individual was not acting as an estate agent. This was, if you like, a one-off transaction. Some of the listeners might be wondering how somebody could get a commission of £1.2 million on the sale of a 6.5 or, as it turns out, £6 million property. And the answer to that was that the person who introduced had been an attempted purchaser and had actually lost £1.2 million in the deal falling through. And so it was a one-off transaction, which I think weighed heavily on the judge's mind and, for instance, meant that those estate agency cases were regarded as not really relevant to this situation.
Yeah, I agree. I think the commercial context in this case is really important because it makes more sense about why there was a threshold above which he got loads of money and below which he got none. Because obviously if he delivered a lower value purchase, the seller would be going, well, I don't want to lose out. Happy to give you a massive load of money if I'm no worse off. but I'm not going to pay you a load of money if I am worse off. So it made more sense of what was going on. I think it's interesting if the first instance judge had decided that the contractor said, Mr. Barton, you get paid a commission, which if you get 6.5 million purchase value is equivalent to 1.2. If he said it like that, then that sounds like it's a commission of X percent. That would have been different, and he would have got whatever the prorated commission was. But the first instance judge didn't say that's what the contract said. Now, we need to let our listeners into a secret here. We're talking as if this is a written contract that said, if 6.5, then 1.2 million. It wasn't a written contract. It's an oral contract. So, listeners, obviously the big message here is don't use oral contracts because you get into this total mess of arguing about who said what. For example, the deal was done in 2013, but the actual initial court hearing was in 2018. So parties were coming to it with memories 5 years old of what, as the judge said, what they hoped they'd agreed at the time with no real recollection. So that's why there is a lot of debate about actually what this contract said, because it was oral and ideally it shouldn't have been oral. I have to say my first reaction when I read it was I thought the first instance judge was really generous to think that there was a contract at all. Because, of course, all the witnesses had differing views of what contract said and whether there was a contract at all. And if I was a judge, maybe I'm just getting old-fashioned, but if I was a judge, I would have said, none of you can tell me what this contract says. You all fail to agree, so why should I imply a contract at all? Why should I say there's a contract at all? Just go away, all of you. You should have written it down if you wanted one.
But ironically, if he had found that there was no contract, then it was more likely that the introducer would have got paid, because if there's no contract, you can go for unjust enrichment. You can effectively say, well, there's no contract, but I've done some work, I've given some value, I'm entitled to be paid for it. And because the judge found, as a matter of fact, that there was a contract, that stopped that unjust enrichment argument. And so where I get to with this case is actually because of the particular facts of it, although it is a Supreme Court decision and therefore binding authority on every lower court, I think that in the future, it could well be that this case will be distinguished on the facts, on the particular facts of the case. And although it's an important decision, it may not be a landmark decision upon which lots of other cases flow. It seems to me also that the mind the gap issue, filling the gap, because the parties entered into a very simple contract. Of course, contracts try to cover as many eventualities as you can. But if you do a deal, which is that if I introduce a purchaser who buys it for 6.5, I'll get 1.2. It doesn't take much to then agree, but if it's lower than 6.5, what happens? And so I think in this instance, effectively, the court thought if that was the deal, that must be the be-all and end-all of the deal. And anything that we add to that would be effectively doing what we shouldn't do, which is saying what the contract should have said rather than what it did say.
Yeah. So key lessons: don't have oral contracts, because if it's been written down in the first place, probably wouldn't have ended up in this dispute. If there is an oral contract, then it's very sensible to write down soon as possible after the contract's formed what you thought the contract said, because that might be really helpful 5 years later when you're arguing in front of a judge. If instead of saying what you thought you remember, you've got a contemporaneous note, even better, one that's been sent to the other side at the time, that's going to be helpful. But if you're going to end up with a contract like this, if something is going to be a real big swing, as you say, that 6.5 was all or nothing, wasn't it? If you've got 6.49, you've got nothing. If you've got 6.5, you won the lottery and got 1.2 million. Given the importance of that swing, it must be worth emphasizing in your contract. Yes, we really mean that. I think the words the judges use is if and only if. So it would only have taken 3 words, probably. But I mean, I think as drafters, we probably put a little bit more than that. But make it clear where there's a big difference, that's understood and agreed.
And perhaps an express term that says that there is to be no implied terms in the contract, because you can't have an implied term to the extent that it contradicts an express term, which was one of the points raised in the Supreme Court.
Yes, absolutely. Yeah, and of course, traditional estate agents would normally have written terms that make this all very clear. But of course, Mr. Barton wasn't an estate agent. He was just trying to do a deal to recover his money, and that's why he fell into this, really. Great. Well, thank you very much, listeners. I hope you found that interesting, a useful insight into the thinking of the courts. It's really interesting in this case that although the Supreme Court agreed with me, that actually two of the Supreme Court's judges didn't. The whole of the Court of Appeal didn't. And that's why if you've got a really important threshold in the contract, it's really important to emphasise what happens if it's not met. Because on a different day of the week, you might have had a different mix of judges who might have come to a different view on this case. Thank you.
Thanks for joining Gowling WLG for this podcast. If you enjoyed this episode, be sure to check out our website at gowlingwlg.com for more useful insights and resources. And don't forget to subscribe to ensure you join us for our next episode.